This is case number 25CR43134, the State of Ohio versus Noah Bays. Mr. Bays is before the court with his counsel, Mr. Booth, Mr. Knippen, Ms. Nicholson, on behalf of the State of Ohio, on the defendant's motion to review and modify bond. Mr. Booth, you may present.
Judge, I filed a motion. I've indicated in my memorandum what my thoughts were. This is the second time I've made this argument, the same argument we made during the time of the arraignment. It is by record that the initial bond was set at $200,000 cash or surety with GPS monitoring. I think, complying with Criminal 46, if we would raise it any higher, we might as well just issue not a bond. The idea of bond is to assure the defendant's appearance in court in a reasonable, fair, and safe way to the community. Mr. Bays lives in a different county. It's up all the way up in Piqua, Ohio. I think that's Miami County, if I'm not mistaken. So there are ways to assure that that's happening. He's presumed innocent. We're still kind of evaluating all the evidence, but I understand, the state's argument where there's smoke, there's fire. It's presumption of innocence. So if we're comparing this to other cases, these are F1s, F2. He's got no prior history. You look at his history. He's always worked. He's got ties to the community. If we raise it any more than $200,000, we might as well just not give him a bond. At this point, it's $1 million. This isn't. It's charged with an attempted murder, which is basically a felonious assault. It's not a murder charge. It's not anything else than what the state's trying to make this thing to be. So we're asking the court reinstate the original $200,000 cash or surety bond that was issued by Franklin Municipal Court judge, and then within 24 hours, the state issued other charges, which the facts didn't change when the original judge issued that bond. When bond was set originally in the original CRA case in Franklin Municipal Court, they were aware of the circumstance. They were aware of the allegation, aware of what the nature of the case was. And at that point, they thought this was the reasonable bond for this case. I'm not sure what happened within 48 hours, but we're here now and it's $1 million. So what I'm asking the court is to give him a shot, reevaluate this thing, make it reasonable. Otherwise, we might as well just not issue a bond. We might as well just say no bond. And that's not what the state is asking. But if we're asking for $1 million or $500,000, that's a no bond to me.
Mr. Knippen.
Your Honor, as the court's aware, one of the things that the court takes into consideration when considering bond is to ensure public safety. And so I think it's important for the court to understand a little bit of the allegations, and then also the court can consider the strength of the evidence when considering the bond. And so for the allegations themselves, the allegation is that the defendant came from Piqua, where he resides, all the way here to Wayne Township, Ohio, and he waited at the intersection of Lytle Road and Ferry Road, parked off of the driveway, waited for approximately 20 minutes until the intended target went to that intersection. And as the intended target approached that intersection, again, it's an allegation, but the allegation is that the defendant then opened fire with a semi-automatic rifle, striking the intended target, Ms. Baer's vehicle, a number of times, as well as striking Ms. Baer, and that he continued shooting, so much so that the vehicle that was behind Ms. Baer's vehicle, completely unrelated to this defendant or having no connection with this defendant, that vehicle also got struck. That driver also got struck. And in addition, as these bullets were flying into the intersection, one of the bullets was discovered into the home that was across the street. And so when you're looking at the allegations, then it goes to the strength of the evidence. And we have the defendant's vehicle on numerous flock cameras and different surveillance videos leaving Piqua, Ohio, coming all the way into Montgomery County, Ohio, Warren County, Ohio, his vehicle being at the location here, parked in that driveway where this shooting took place, and then we have the defendant's vehicle leaving that area after the shots occurred. Additionally, from that location where the shots were fired, there were numerous casings that were recovered. Those casings ended up matching the firearm, the semi-automatic rifle, that was recovered from the defendant's room just hours after this shooting occurred. So when you're talking about the strength of the evidence and ensuring public safety, I think the strength of the evidence is extraordinarily strong in this case, that this defendant came down here, the intent and the purpose to kill Ms. Baer, who's in the courtroom today, and not only did he have that desire to shoot and kill Ms. Baer, he also was willing to disregard any consequences as to what that shooting might entail. And we know that from the fact that it struck a secondary vehicle and it struck the house across the street. So again, when you're talking about the risk to public safety, the risk to public safety if he were to be able to post his bond and to be able to be out and monitored is extraordinarily, extraordinarily high. The other thing I'd ask the court to consider is whether he's a flight risk. You're talking about someone now who is charged with 2 counts of attempted murder, multiple counts of felonious assault, discharging a firearm near a prohibited premises over the roadway, and discharging a firearm at or into a habitation, all of those with firearm specifications. If he's convicted of these charges, he's looking at a mandatory minimum in this case of 9 years in prison, all the way up to potentially 53 years in prison. So I do think when you're looking at the seriousness of the charges and considering whether he's a flight risk, when someone knows that if they're convicted, they're going to prison for at least 9 years, up to possibly 53 years, that makes them a flight risk as well. So for all of those reasons, we would ask the court, at the arraignment, the state asked that the bond be increased to $2 million. I don't think that's an unreasonable request, given what we know about this case, the facts regarding this case, and all of the harm that the defendant put others into. But at the very least, the state would request that this court keep the bond still at the $1 million figure that was set at arraignment. Thank you, Your Honor.
Mr. Deary is here. He represents, my understanding, the victim, one of the alleged victims in the case. Mr. Deary, do you wish to be heard?
I do, Your Honor. I do represent Emily Baer, one of the alleged victims in this case. I have represented her for the last several months against the defendant, Mr. Bays, in the Warren County Juvenile Court regarding the custody of Mr. Bays' daughter. My client has been the primary legal custodian of the daughter since she was a baby. Ms. Baer asked me to appear here today, Your Honor, to endorse the position of the state regarding the motion to lower the bond here. Ms. Bays was, as far as we can tell, the primary target of these offenses. She would be very fearful for her safety were Mr. Bays to get out of jail. I do understand why Mr. Bays wants to get out. I think the motion is well written. There are other mechanisms this court can use, but there's nothing as effective as just keeping this defendant behind bars to make my client feel safe while this case is pending, for her own safety and for the safety of Mr. Bays' daughter, the minor who my client has raised since she was a baby. So for all these reasons, Your Honor, my client vehemently opposes a lowering of the bond here. We would ask that the court deny the motion.
Thank you, Mr.
Thank
Deary.
you.
Anything else?
Judge, I just want to address for the record, and I can certainly appreciate Mr. Knippen's statements before the court, but obviously we're not trying this case today, and I didn't want to object to any of the statements made, but I'd like to remind everyone in this court that Mr. Bays is presumed innocent in what Mr. Knippen said and what we discussed in chambers. There are no witnesses that are going to put Mr. Bays there. In fact, there's evidence that shows by virtue of his cell phone that says he wasn't even near this county. So we're using a mechanism by saying there's value of a vehicle and we've got some casings and we want to keep this guy locked up. We want to have no way of letting him get released because we don't believe he's presumed innocent. It sounds like
Well, let me stop you there because that's not, that there's a bond set. He's not being held without bond, so that's inaccurate right off the bat. But I've heard
Judge,
enough.
$1 million.
I'm not, listen.
$1 million.
Mr.
on a case like this.
And Mr. Abood,
Yes, sir.
with regard to these allegations, and again, you're kind of referencing the municipal court setting bond, you would agree that the charges were upgraded between that time and the time that he was indicted, correct?
Yes, sir, they were updated,
Okay.
but the facts remain the same. That what was my point.
But I mean, all I know is allegations at this point in time. I don't know what the facts are, because the trier effect hasn't determined what the facts are. So we'll wait for that day to determine what the actual facts are. But certainly, everything that's been raised here, both by you and by the state and Mr. Deary in this case, are all accurate. So it's just a kind of a balancing at this point. But the court is going to find that the $1 million bond is an appropriate bond at this time. I want you to go see Jennifer. I want this motion to suppress set for a hearing. How much time do we need for that?
Half day, Your Honor, just
All
to be
right,
safe.
then let's get that on the docket, and then we talked about the 30 days to let the state know, or the court know, or both, with regard to this motor vehicle and whether it needs to be retained for any evidentiary value. Anything else?
No, Your Honor.
All right, that's all.
I'll be over to see him. He's going back to the. What's up? Am I able to come see him?
Two people are in the hospital after a shooting at an intersection in Warren County. Thanks for joining us at 5. I'm Rob Williams.
And I'm Allie Hennard in for Tricia Mackey. Our Ken Brown has been at this scene and joins us live with more. Ken, what do you know?
Well, we know that this happened on Lytle in this area. I do want to actually step behind the camera for you guys. You see the cruiser over my shoulder, obviously, but in the distance, I think more importantly, what you're seeing is the crime scene unit way off in the distance. As you mentioned, 2 people were shot, 2 women were shot at this intersection, and you can see in the way back there, a van that we believe may be involved in all of this. We did hear from the Warren County Sheriff, who told us a person of interest is in custody or has been detained in this case. So we're still waiting to get more information from them on that. But what we do know is that the 2 people who were shot are expected to be okay. They are non-life-threatening injuries. Both those women were taken to the hospital where they are currently receiving treatment. And as I mentioned, we did hear from the sheriff's office just within the last hour and a half. Take a listen.
The person of interest is detained, so area residents should be, everything's secure now. They do not have to worry. We need to head to their location, speak with them. Any search warrants that we may have to do.
Obviously, there are still some steps to take in the investigative process here. One of the questions that we had, given that this happened on a rural road in the middle of an intersection, was, is this road rage? And at this time, the sheriff's office isn't commenting any further on what led up to this, why this happened. Their investigators obviously still working through their process in all of this as well, but we'll, of course, continue to follow this story and bring you the very latest. For now, reporting in Wayne Township, Ken Brown, Fox 19 Now.